Good afternoon, good morning, good evening, wherever you may be. My name is Barry Nicholsberg. I'm Chief Development Officer for Estate and Gift Planning at the Carter Center, and we are delighted you are with us here today. Our program today, well, we'll tell you about that in just a moment. I really would like to thank Jane and Ruth are two of my absolute favorite people in the whole world. When I started at the Carter Center 12 years ago, somebody, actually, when Mark started about 5.5 years ago, he said, he asked what I like best about the job. And I said, the wonderful friends. They are truly like family. And he has come to understand that. And our two guests today are exactly like family. And so I look forward to hearing from them. I want to thank you all for supporting the Carter Center, if you do. And if you don't, it's okay. We want you here nonetheless. I also want to thank you for having trust in us to bring you information on a monthly basis through these webinars. But right now, I want to turn it over to Mark, let him introduce our guests, and away we go.
Excellent. So my personal favorite place to come in is the incomprehensible wall of legal text here. Don't worry, we won't read it all. What I will do is tell you that Jane and I are both attorneys, and because of that, we have to have this fun disclaimer. So what that says is we're just not going to be giving any legal advice today. All we're going to be doing is trying to educate you. What we really do want to do in this opportunity here is just take a moment to note that this is a really, really important topic. A lot of folks are really sort of still caught this mindset that trusts are something that are sort of just out there maybe for the rich. And so they don't think about whether or not they may need to plan for things like a trustee themselves. But as we have this conversation today, I think you'll come to find that the trust is a much more powerful tool and much more useful tool than perhaps you might have originally thought. So hang with us. We'll get to some of those points and you can see that. And without further ado, I get a chance to come and introduce you, Jane. Jane Hall is a wonderful member of the Carter Center's Philanthropy Council. Just quickly, that is a council that has been put together comprised of folks in academia, folks who are professional advisors like attorneys and financial folks, tasked by President Carter with basically a dual mandate to increase the amount of philanthropic resources that are out there and their effectiveness or impact. So in that line of work, Jane has been a wonderful addition to our council. She is the chair, and in addition to that, she's also a founding partner of her own law firm and has an extensive career in tax planning, trusts and estates, and all of the things we're going to be talking to you about today. So that's one of the great things. We pulled together two folks who are going to be able to approach this from different directions. So Jane is our professional advisor, and Ruth
is our professional trustee.
That's right.
I jumped all over that, didn't I, Mark? Ruth is a dear friend who I feel like I've known my entire life. She is actually a professional trustee, in addition to many other things. And with that, I think it's enough. Let's get going. Mark, you have a first question?
I sure do. And Ruth, I'd like to ask you to answer first. Just how would you mind telling us how you found out you were going to be a trustee the very first time?
Well, first of all, thank you very much for having us here, because it really is a pleasure to work with the Carter Center. And I have had a wonderful time, as I hope everybody else has. I started because we have a family that is 5 people, 3 children, a father and a mother. This was back in 1990. My brother is a lawyer, and he thought it would be a good idea if we could have a family trust. And so he set it up in such a way that my mother and father were first trustees. They were the ones that were going to decide. And it was a living trust. So all of us became partners in something that would happen, hopefully, in the way they wanted it to happen after they passed away. My mother died first, and then it went to my father. And me, who was the eldest of the 3 children, 2 brothers and an eldest sister is absolutely the way to go. And so my father and I were the trustees, and my brother, who had set up the trustees, is in California, was at that time. And we all worked together to make this something that was never changed from 1990 until the time my father died. The thing that was interesting about it was the setup. And I would say that although I'm a trustee, the most important thing to do is to set up a trust that really reflects what you want to have happen. Then get a good trustee or group of trustees that can carry out those wishes exactly the way you want them. And I think if you can do that, you can rest quite easy that things will happen as you wish them to happen if you're no longer here to pilot your own life through. Does that answer your question?
It sure does. And if I may follow that, actually, Ruth, I want to just get to another thing that I didn't get to before. Would you mind telling us how many times you've served as trustee?
Oh, mercy. I honestly don't know. It's been,
Not a problem. That's
it,
exactly the kind of thing I would hope that would make the impact on people. It's been so many times you don't know.
I don't really remember, but it's been many times and many different people, and most of them have been wonderful. But I will tell you that there are times when it doesn't work out, and you need to be absolutely honest. That's the biggest thing, is to get an honest trustee who will work with you as a partner, but also if it doesn't work out while you're still around on this earth, you've got to cut and get another trustee. So, but most times it's worked out quite well and we've had a wonderful time.
So I wonder if you might also be able to tell us, Ruth, about how your conversations with these folks where you've served as trustee have actually their wishes, their desires, those conversations have guided your actions when you were serving as their trustee.
Well, I think the first thing is to listen. You can't really understand what people really want unless you really listen to them, and they have trust in you to be able to give you all the information, not all of the nice things, but all of the stumbling blocks that you may run into. In any family, there are activities or members of the particular family that change somehow when money is involved or trust of things are involved. And so I think that the person who is the trustee not only has to have a good trust to work with, but also people that are candid with each other. And when you have problems, to really face them and try to solve them rather than glassing over them or wishing they would go away. They don't. And it's important to head those off if you can, but also to make sure that you are really in tune with what the trustee wanted, what the grantor wanted.
Excellent. That is wonderful, Ruth. And Jane, I'm going to propose a similar question to you. And so I'd ask, as you're working with folks who are establishing trusts, they'll be trustees themselves, or they have found themselves recently as a trustee. As those conversations are happening, those choices are being made, do you typically suggest that folks talk with the people who they're going to ask to serve as a trustee?
Well, yes, there's actually three kinds of trustees. Well, four kinds. There's the grantors themselves, okay, that are usually the initial trustees on revocable trusts, at least here in California.
Yeah, the people who create the trusts.
On revocable trusts, not irrevocable, because that's a different animal, but on revocable trusts, you've got the grantors or grantor, and then you can pick a family member or friend, or a private fiduciary, someone that's paid to handle. I think Ruth is more a private fiduciary for some people that are not her family members, and she's doing it as a arm's length to some extent. And then there's corporate institutions. And so Ruth said that you have to listen, and she's so right. And for us attorneys, we have to listen really carefully. What we're drafting reflects what the grantors want, because in estate work, grantor intent is the name of the game. So what does the grantor want? What do they want for their minor children? What do they want for their trustee to hand out money to people? And how do they want the money divided, for example? So I think it's really important that they talk to whoever it is that they're going to appoint. Occasionally, someone will appoint a big bank like US Trust or Northern Trust without talking to them. But most people talk to their potential trustees and set it up ahead of time. And a lot of times it's awkward because, let's say, all their relatives are in India, or all their relatives are in Iran, or wherever. I mean, sometimes you want to pair up a family member with somebody else. And so it's a kind of it's solving a puzzle for most people. And then in addition to that, just to add on, there's a difference on a trustee while you're incapacitated, so that when you wake up from your coma, your money's still there, versus who handles out all the administration after somebody dies. And so I think there's permutations to that.
That's great. Thank you so much for setting out those different considerations of time and potential places where a trustee might be needed. That's incredibly helpful as we're sort of walking through this conversation. And so I wonder then if you might talk to us a little bit then about how trustee wishes or conversations may actually be respected or potentially not if you go with an institutional trustee or a professional trustee like a bank, as opposed to an individual or a family member or a loved one.
Well, sometimes the banks are better than the family member or the loved one. It kind of
Surprising.
depends. I mean, it's an incapacity trustee and they're going to get all the money at the end of the day and it's all being spent on long-term care, they may not be quite as good at doling out money liberally for the person who's incapacitated than a bank would be. On the other hand, if you put into the document guidelines of what you want. I make the joke with people, do you want tennis lessons for your children? You know, you don't really want to get at that level. Every once in a while somebody does, but you don't want to get at that level, but you might say, I'd like them to go to any college, any higher education institution they want to go to, so that the trustee doesn't say you can't go to Harvard. You know, or I don't want them, they can go to any state school they choose. You know, I've had people do that. So you can integrate your wishes in there, including disinheriting people, including, you know, if you have a drug addicted child, how the money gets doled out and not knock them off of governmental benefits that are sometimes better than others. So it's really a function of listening really close and then overlaying your own expertise and your own experiences, because a lot of us who do this have seen a lot, you know, so then you can talk it out with them and say, well, what do you think about this? Because I've seen this happen, you know.
That's a wonderful thing to point out, that experience that you as an advisor and Ruth, you as a trustee, allowing that to be your guide. So I'd like to sort of move on. I won't ask exactly the question that you see in front of you, but instead ask you, Ruth, could you talk to us a little bit about the initial conversations that you had with people when you were evaluating whether or not it would be a good fit to serve as their trustee?
Most of the people that I have served as a well, first of all, I'm old. And that means that I've had a lot of experiences in my life and been with a lot of different people in a lot of different areas. So I've built up networks of people who, for one reason or another, have asked me if I would be a trustee for them. The questions that you ask really are much more personal than sometimes people are comfortable with. And I think that's an important thing to take into consideration. The other thing is that when you talk to the people, you really want to find out exactly what it is that they want to have emphasized in their trust. There may be some things that they want to go over very lightly. And it is important to me to work as a team as much as possible with the lawyer, with the accountant, with anybody else who's involved, and if possible, to meet sometimes with the family. I have done it with people who I didn't know, and in those particular cases, I've spent time trying to understand what it is they really want to do. So it's a work that has been done, hopefully, with the lawyer, but it's also a work that is human. And it brings in all the foibles and all the wonderful things that human beings have. So it takes somebody, I think, who is a trustee who is not just a bean counter, but is a bean counter who cares about people. And I think you have to be both, because this does involve money. It does involve the trustee having to spend money and time on something that sometimes takes up a great deal of time. So you need to think about that if you are asked to be a trustee, what it really means to the people to have you and what they really want to have you do.
That is just really excellent, Ruth. I'm so grateful for that level of explanation there. And I'd like to follow on to that, Jane, and ask you similarly, if you might talk to us about the kinds of discussions you have with people as they are either establishing their own trusts and becoming trustees themselves, or people who are recently finding themselves in that position. What kinds of things do you tell them? I know it's a huge, wide open
Well,
question.
no, I think the most important thing is I say, especially for incapacity, because people forget about incapacity. They come to lawyers because they want to avoid probate and who's going to get their money when they die. And they forget that while they're alive, that's probably, unless you have little children, the most important time is while you're still alive. So I say, who do you trust to be a tiger for you? Who do you trust to take care of your money, to make sure that the person who's taking care of your health care is getting the assets they need? I talk about that most trusts that I draft, unless I'm directed otherwise by the client, say reasonable compensation. They're going to get paid. What are they going to get paid? If you're picking your accountant, are you going to pay your accountant's hourly rate? If you're picking your lawyer, you're going to pick your lawyer's hourly rate. So who do you want in that position? And the banks charge a percentage of assets under management, but they also charge extra for their lawyer, for their accountant. That's the kind of thing that can get pretty expensive. So, and the banks don't want an estate that's very small. So that's not an option for people who do not have a significant amount of money. So, I mean, I go through with them, how do you feel about, and sometimes like if it's a couple and they have children and they have money and they're worried about one or the other side of the family having too much control, you can pair up a sister of the husband and a brother of the wife as co-trustees for those children until they reach 30 or 35 and miss their first divorce. And you're kind of easing into, so we talk about things like missing that divorce, not letting their 25-year-old share all their property with their spouse because they're in love and then end up with less money. So you want to talk through the kinds of issues. And if there's a drug addicted child or that type of thing, you got to talk about who can handle that. I mean, maybe you have to have a private fiduciary in those instances because, first of all, it might go on for a tremendously long period of time. If it's a special needs or a drug addicted adult. And so they need to understand what they're getting into. I have a 99-year-old client who fires everybody, who I recently talked her friend into being her trustee. And I talked her friend into it because there is nobody else. And she wasn't open to a private fiduciary. And the problem is I got a care manager involved. And then she fired the care manager, and the care manager is what enabled the other person to be her trustee. And so I kept telling her, I don't care about the care manager, but I care that you're going to lose your only choice for a trustee. And since she fires people all the time, she probably fired me too. It's just one of those things, but that's how she shows her power at 99, is firing people. But she's also totally dependent on her attorney and her named trustee in a way that most people who haven't outlived all their friends and relatives are.
That is a really, really great way of sort of encapsulating a lot of issues that I had not thought of, but I'm sure there are folks who are sitting out there thinking about this too, that, now there are more things to be aware of. So thankful to you both for being able to share that with us. And as we move on, I'd like to talk a little bit more about the trust process itself. And Ruth, I'll ask you to first talk, if you can, about sort of what you viewed your role as trustee sort of as being within that trust process, because I think that that's an important part to capture as well.
Yeah. Well, most times I've come in when people have figured out they want to have a trust or have already set the trust up. So, and as I said before, most times I've known the people through various things that I've been involved in. But I think when the trust is set up, you have to go over that trust with the person to make sure that what is in that is exactly the way they want it. And if you're working with a lawyer, and they are, and you also have a health proxy, and you have a power of attorney person, you have a lot of people that are involved in this whole thing. And as Jane says, sometimes you've got people who are out for their own purposes, not for the the grantor's purposes. So you have to sort that through. But I think that mostly it's an uplifting conversation. I do think you need to have a sense of humor, because you're going to run into some real sticky wickets, and you also have to have some kind of ways of negotiating. And if you have been with people for a long time, I think that's a helpful trait to have. You also have to do things legally. I mean, you have to really toe the line, because you're not just in there willy-nilly. You're in there to do something that is extraordinarily important and has legal ramifications as well as personal ones. So
What a perfect tee up for Jane there to talk about sort of how an attorney gets involved in the trust process. Would you mind talking a little bit about how attorneys work within the trust process, either in aid of the trustees or in creation of the trust, perhaps both, Jane?
Sure. So when a client comes to see me, they may already have a trust, or they may be starting the process and don't know much about having a trust. In California, most trusts that are the type of trust we're talking about here are revocable trusts. It's a living trust because you're alive. A lot of states have testamentary trusts that get set up at death. But here we sit down and we go through who they want their trustees to be, who do they want their property to go to, who do they want their diamond engagement ring to go to, and who determines if they're incapacitated? Is it their spouse and a doctor, two doctors, a committee? I mean, and so then you draft on that. And I will say, and I think this is extremely important, is that trying to do a really quick job to put a trust together some of the online programs. I've seen some horrendous things come out of that. I've seen some horrendous things come out of attorney drafted trusts. So if the ambiguities, when you don't say it clearly, what is supposed to happen, cause lawsuits. And so I have a case right now where it's so poorly written that they've spent tens of thousands of dollars on attorneys trying to juggle how the estate is going to be, and it's not done yet. It's been 2 years, and what a shame. If it had been clear at the beginning, but the attorney was not a trust attorney, he was doing it as a favor for his friend. If it had been clear, we would have been done in 6 months to a year, and trust administrations take a while. So there's that part about the drafting, and then you get the part about when somebody becomes incapacitated, which may or may not turn the trust irrevocable, and who is taking care of that trust during that time, and that they need an attorney to take charge of things probably. And then in addition to that, you have after someone dies, you have a trust administration, and the trust administration, at least here in California, requires some statutory requirements. We have to send the trust out to not only the beneficiaries named in the trust, but also the heirs at law. That's something my clients hate, but it is required in California. We have to notify the Department of Health to see if any money's owed. And we have to, same with the Franchise Tax Board, the taxing authority here. So there is a bunch of stuff to do. And I think people think that, well, we have a trust, we've avoided probate. Yes, that's true. And in California, probate is horrendous, but you still have stuff you have to do, and you probably should do it with an attorney. But people resist that. They resist hiring the attorney on the front end. And let me tell you, that often creates major issues after somebody dies. And a lot of times the siblings or whoever don't end up ever talking to each other again because over something that could have been avoided by good drafting.
That's right.
That's a really wonderful way of outlining sort of the field, if you will, where people are playing, to both of you. Thank you so much for that, because I think it helps us to understand, okay, if we sort of are, the 10,000-foot view looking down at the field, we kind of see how the pieces move about. So I'd like to go a little bit closer now and ask you both about this next question. So as we've talking about these different things that you need to do, Ruth, I wonder if you might talk about the kinds of documents and things that you've needed as you've served as a trustee to actually do that job well.
First of all, I am not a professional in the sense that I don't have a license or anything. And as far as I know, very few trustees are monitored. So which may or may not be a good idea, because you could get somebody who's really not helpful to do this. As far as documents are concerned, the documents that I have dealt with have mostly been in the trust themselves.
Mm-hmm.
There are times when the lawyer sets up the trust and that's it. They don't want to have anything else. The grantor doesn't want to have anything else to do with them. And as Jane says, in a living trust, as long as you are living, you can make changes. Sometimes the people who are the trustees see something and the grantor has changed his or her mind, and they haven't changed anything in the trust. And that is a problem, but it's something that the trustee needs to be on top of enough to do something about it. Many times the death certificate has to be, you have to have X number of copies of the death certificate to give out to stop credit cards and whatever else you need to have. And sometimes that involves a lot of footwork that you have to go various places. As Jane says, most of the things are done through the legal process that she did. But in sometimes that is not the case, at least with some of the experiences I've had. So it's not that I have documents that I have to deal with on my own, but I have documents that are important that have to be dealt with as far as the trust is concerned. And it isn't just a slam dunk. You don't just make out the trust and have it, oh, this is wonderful. The job of the trustee is while the person is living, but also when the person passes away, and you want to make sure that everything that they wanted happens as best as you can.
That's fantastic. And Jane, kind of drafting on that, as we heard Ruth talking about this interplay between the people and whether they're living or whether they've passed on, I wonder if you might talk to us again then, sort of before someone might pass away and maybe after someone passes away, if there are different documents or there are different things that they might need to be aware of with respect to the trust. Sort of what I'm getting at is whether or not there are other documents from the estate planning package per se, things like powers of attorney and things that might be helpful to a trustee, and whether or not there's a difference when they might need those before a person passes or after.
So let me add something on to what Ruth
Please.
said first, which is that a living trust, you have to actually transfer titled assets into it. So if you don't transfer those titled assets, and it doesn't help that they're just named in the trust. Okay, so if it's real estate or stocks, bonds, you actually move the title into the trust, or it doesn't work. are works in California, which our friend Steve Hartnett, who's listening, who's the American Academy's national tax expert, would understand as well as I do. But you don't push those in. They could be probate assets, and you've avoided the point of the trust. The trust is meant to be private to some extent and to be avoiding probate. So that's one thing that's really, people make mistakes. They don't move those assets in, so they buy a new piece of property and it never gets in the trust. And then they mark up the trust with the changes they were going to get around to make, which might invalidate the trust. And there's all kinds of things you can do wrong there. But so in addition to a trust, an estate plan has a durable power of attorney. It handles things outside of the trust while you're alive. That is retirement, life insurance, Medi-Cal, Medicaid, medical insurance, Social Security, and some other things. And so there are things that are outside of the trust that need to be dealt with when somebody's incapacitated, and the durable power of attorney allows the named agent to handle those. They're not in the trust, so the trustee can't do it. And it's really important question, Mark, because without that durable power of attorney, you could feel like you were inept as a trustee because you couldn't handle these other things. And then we have an advanced healthcare directive, which says who can handle your medical choices when you can't. And in addition, a HIPAA, which says who can get your medical records if you're incapacitated. Lots of times people want living will language. A living will is a different thing than a living trust. A living will basically says turn off the machines if I'm a vegetable. Right. And so lots of times people have a living will or language in their advanced healthcare directive that reflects that. There's another document that's kind of an anomaly to most people, but it's called a certification of trust. And that document says to a bank or whoever, I'm the trustee, trust me, there's this trust and I'm the trustee. So when someone gets either incapacitated or dies, you have to change that certificate of trust to the new trustee so that the new trustee can go take over the things that are in the trust that were being handled by the original trustee or whoever. So I don't know if I answered that right.
No, that's perfect. That is exactly what I had hoped, that people would understand that potentially there are going to be other documents or things at play that may impact what's going on with the trust, particularly. So may I ask first, could it be possible that the person who is named as trustee for someone might also be named as the person who's exercising the advance directive for their health care or their power of attorney?
Yes, not only that, it's a really good idea, but it also, they're named, you usually have a will with a living trust. It's called a pour over will. It means that if you left something out at the end of a probate, it pours over into the trust. So the best case would be to have the same person or people named in all three roles: the agent on the power of attorney, the trustee on the trust, and the executor or / personal representative. They means the same thing on the will.
Wonderful. And so if that's not the case, it's conceivable that a person who steps in to serve as a trustee is going to have to be familiar with those documents and perhaps working with someone who's outside of the trust to provide care for the person, to pay the bills that are there for the person. Is that correct?
That's correct. And lots of times people say, oh, I just want my daughter on the power of attorney because she'll be the one that pays the bills, but I don't want her to be my trustee because she really isn't good with money. And I have to try and talk them out of doing that, because the trustee can give the daughter money to pay the bills, but you're really handing the incapacity trustee the ability to handle everything. And so then you're kind of cutting their arm off to not let them also be the agent, because they're interrelated from a financial standpoint. But, it really depends on the person.
That's great. Ruth, do I see you?
Mark, I'd just like to interject here.
Please.
That Jane is telling you how important it is to have a good lawyer. The best thing, the most important thing is to set the trust up so everybody understands what it is, and all the people who are involved really know what the situation is from the very beginning. And because it is a living trust, that's a wonderful opportunity for people who do see something that they didn't see before to change it. And so picking your lawyer in the beginning is truly the most important thing you can do.
I'd
So
like
that's
to
a,
add to that,
please,
Mark,
yeah.
is that when people come and see you and you say to them, who do you want the guardian of your children to be? Who do you want to handle your money if you're incapacitated? I mean, sometimes they just kind of glaze over. I mean, they really can't handle what that really means. I mentioned last time we were on that I have a client who was the heiress to a composer and didn't want to talk about death, but was always changing her estate documents, which was clear she thought about death all the time. And so, but I think that it's really, really important to look at it like it's amendable, like Ruth has brought up, that you can change it. If you're not incapacitated, you have an opportunity to change it. They sort of can live with it for a while. And then as things come up and they hate that brother that they named as the trustee, then they can kind of change everything. But hopefully it will last for a few years.
And flexibility then is one of these things as people are considering a trust and they want to try to build in from the outset. Would you say, both of you?
Yes.
Okay. I'm very glad that you set us up in this way because it's really leading us to a conversation about the actual sort of day-to-day responsibilities. And so I'd ask you first, Jane, if you could talk to us a little bit about trustee responsibility. And I know that's kind of got some loaded vocabulary in it per se, as we sort of get to this idea of a fiduciary. So I wonder if we might explore that a little.
So as you just said, a trustee is a fiduciary. A fiduciary is supposed to take care of not only the primary beneficiary, maybe who is the grantor who's incapacitated, but they're all supposed to take care of all the beneficiaries with equal protection. They might not have equal shares in the estate, but they're equal protection. The trustee's supposed to pull together an accounting for the beneficiaries. That can be really dicey because sometimes the trustees don't have that skill set. So we're back to the team that Ruth mentioned, which is your accountant, your trustee, and your lawyer. So, I mean, I have to twist people's arms sometimes to put that accounting together. And then you have a recalcitrant or an obnoxious or whatever beneficiary insisting on seeing all the underlying documents for that accounting. And so, and they probably have the right to see that. And so you have to kind of weigh, cajoling some less experienced trustees. But if you had a Ruth, she would just be getting the accounting together as she did everything else she does. And so, and then there's always the aspect of a little bit of self-help. Does the trustee have the right to transfer any assets to themselves? How about the ones where it's the diamond ring goes to the daughter? Can you give that out ahead of time? I try and get my trustees to not start distributing anything until everybody has signed off approving the accounting. Everybody's signed off of a release of the trustee and me. That doesn't always work. If it doesn't work, you go to court and get the accounting approved at the courthouse, which of course is expensive, but I have people that are wasting hours and hours of attorney time and trust assets because the attorney for the trust gets paid by the trust. So if you have a beneficiary that's unhappy and they sue, most trusts have a no contest clause. I think we talked about this last time, that if there's a clause in there that says if you sue this trust, you're going to be treated as if you predeceased the people that died. And so that's a real disincentive. Another way to deal with that is to give them $100,000 so that because if you give them nothing, they don't have a lot to lose. But if you give them $100,000 or to their kids, they might have a lot to lose to, contest the trust and then be treated as if you're deceased. Where you see a lot of conflicts come is on the accounting. It's on how did you spend the money? Why did you spend the money on those lawyers? Why did you spend the money on that accountant? Why are you spending money on yourself? Because you're the trustee and you're paying yourself. I don't like it. I don't want you to do that. So lots of times the contests come from either ambiguous language needing to have a court decide what it really says, or the accounting has some issues around it.
Fantastic. That is just excellent. Ruth, I'm wondering too, if as we're talking about this, all of these sort of technical things that have to get done, could you talk to us about your experiences on a day-to-day basis, the kinds of things that you needed to do to serve these people and their trusts well?
Well, I will say that each one of them is different. I have not had any that are the same. I think the main thing is, uh, first of all, to understand that this does take up a great deal of time. This is not something that you can say, oh, goody, I'll get it all done in a day and a half. That doesn't work that way. So you have to understand that there is time involved. But the other thing, as Jane has said, is this is something where things have to be done accurately and they have to be done legally. And so whatever you can do while the person is living, that's to me the most important thing, to build up the trust that you have, hopefully, with the people who are going to get the monies and the assets of the particular person. The thing, I guess the thing that is the most difficult is if you have someone who thinks that this is not fair. The fairness doctrine is really hard to do because you want to have that done hopefully before the person passes on, and that everybody understands that so-and-so is going to get something that I'm not getting, but in all fairness, I'm getting this, that, or the other thing. So it's a dialogue that needs to go on while the person is living if you want to have a more smooth time after the person dies. And that's, I think, the most important thing, at least in my experience of dealing with people.
So I'd love to ask you both if you could comment about, Ruth, if I'll ask you to go first here, how the trust document either empowered you or tied your hands. Were there things along the way that you were allowed to do or not to do, maybe on either of those that were unusual to you?
Yeah. I think for the most part, most of the people, first of all, we've built up some kind of a friendship or a trust in each other. I'm not talking about the physical trust. I'm talking about the person to person. But I think the other part of it is that, as I've said in the beginning, this is a living trust. And so all of the things that you do while the person is living, that's the most important thing. I think I've gone off on a track here. Bring me back and tell me what you want to,
Yeah,
I'm not answering.
no, that is really good because it does get back to this idea that certainly those folks who have put these trusts together have done it, and they've put things in that they want you to do or perhaps not wanted to do, and they formalize that within the trust document itself. Would that be right?
Yeah, it is. I think that that's the thing that's the most important thing to do, is to understand you can change something if you don't like it. And as Jane has said, getting those things done while you're living is a heck of a lot easier and better than trying to figure it out at the end of the road there.
Excellent. And Jane, could you talk to us a little bit too about sort of the importance of what the trust says you can or cannot do, how that might impact the person serving as a trustee?
Yeah, it's interesting because trusts tend to be kind of long. They have a lot of verbiage. People ask me to take out the farm and agricultural clauses, and I won't do it because who knows what they're going to do later. But one of the things that happens is that the language in the trust can be too restrictive or too broad, depending. And so the more you can pin down what the grantor really wants, the more you can have that leeway, because you can't bring up any kind of situation that's going to happen. There's no way you could cover it all, but you can have guidelines in the trust to tell the trustee what to do, and they still get confused or need legal advice. And sometimes the legal advice isn't all that helpful because it's not that clear in the trust itself. I did want to add that under a lot of the old trusts that the tax language is out of date. So people who did their trust in 1990 need to have it looked at again. Another thing I wanted to bring up is that we've talked about living trust today, but a lot of the same issues we're talking about are also true for irrevocable trusts, ones that you can't change later, or you can only change out who the trustees are or whatever. Because if that language is not clear, then you're stuck with it forever. So it becomes the drafting, and Ruth and I are in total agreement on that. The drafting of it is like the core, it's the directions, it's the basis of what's going to happen. And none of us are perfect, us drafters. I mean, we don't get it all, but we try really hard to get it as close to what will work. And I mean work rather than locking down everything about it. You need to have it be a little flexible. I had one couple who had a sheet on how their kids could get so many dollars per month for the rest of their lives practically. And that is not a very good idea because lots of things happen. And the human part comes in of trying to interpret that in the most effective way that's fair to everybody and honest.
So making sure we've got specificity and being clear from the outset is a must, just a must.
And having a trustee that is not so rigid that they can work within the parameters of what that trust says without it hurting the people that are supposed to be helped by the trust.
I think, and also to make sure that while you're working with the person who is alive, to have them be as candid as they possibly can be. The more candor you've got, the better it is for everybody.
Excellent advice from both of you. Thank you so much. I want to get on to one that I think is somewhat maybe totally subjective, but I'll ask you both if you could talk about the surprises. Ruth, as you've been serving, has there come up a time, a situation that you've ever just totally shocked? I'd love to hear about any of those.
Well, the biggest surprise that I had was a cat. And the cat was supposed to go to one of the daughters. And this was all well and good until the daughter figured out that she was allergic to the cat. And there was no one else to leave the cat to. And so after this wonderful thing happened, I'm saying, what the heck am I going to do here with this wonderful cat? Well, working with the lawyer, but also working with some of her friends, there was someone who would absolutely adore to have it. And so the cat had a good home and everybody was happy. But it became something of it was not only a surprise, it was just the person couldn't handle it physically. I mean, she was allergic and she never knew it until the cat came to live with her and all she did was sneeze. So that was the only surprise that I really had that was of major. I've been lucky. I haven't had a lot of real difficulties. So,
but that is a wonderful surprise that illustrates for all of us out there with fur babies, pet children at home, as we plan around those things. It's so important to be thinking about those things, particularly if you're going to be setting up a trust that might benefit your animals. Last month, we had some folks on who are our speakers who have in fact done this for their horses and their gray African parrot and a few others that they expect to outlive them. So thank you so much for that, Ruth. That's really excellent. Jane, would you care to speak to any of the surprises that have popped up for your trustees or families who have worked on their trusts?
I was going to mention on cats, it's a joke in my community that someone sets up the house that they don't really, a lot of people don't realize that their house is probably going to get sold after they die. I mean, we're all attached to our house, so it's hard to picture that. So the house was going to be used by the caregiver as long as the 20 black cats were alive. And if you can imagine that there never was not one of the 20 black cats, because, or the blue canary, that it was easily replaceable would be, So that was one. One that I had was the woman whose child had an arsenal. I mean, and he was threatening the father. And so that one was a tough one. Who's going to be the trustee for a guy who is paranoid and threatening anybody who gets in his way? And so that one, we actually were able to get a trustee that was a financial person involved with the family who was on the East Coast. And so it actually was a good thing. He was very far away, a little more removed, and there was a lot of money, and this kid would be getting that money doled out discretionarily by the trustee, which was a good thing. But he kept getting arrested, including his dad would get him arrested. So, somebody in jail, that's a problem. And I've seen some really, we had a 2-week period where 2 different people were murdered. Not my clients, but their family members were murdered within a couple-week period. And my daughter, who worked for me, wrote a haiku. And the haiku was, phones ringing all day. Client said his son murdered his mother, had wine at lunch.
Understandable on
And
that day.
I
Wow.
thought that sort of epitomized what we hear, I mean, we hear a lot of stuff. And so when people come in and tell me their family's dysfunctional because their 2 daughters don't get along, I go, you have no idea. You just, you have no idea.
Count the blessings. Absolutely.
That's why it's good to have a sense of humor.
And this
Yes.
is exactly the kind of thing that I was hoping you all might share, because there are just so many variables, so many dynamics. It would be impossible to name them all, but these are 2 really good examples of things. Just be on alert out there, folks, as you're doing this. There's a lot to consider. So as we're going forward, I'd like to talk again a little bit about the disagreements. We've kind of talked about that up to this point. And so, Ruth, I'd ask you if along the way in administering your estates, have you ever run into a situation where you had to negotiate a disagreement, and how did you go about that?
Absolutely.
Before-
Yes. There have been people who have disagreements, and that's why I said that people who have now are going to inherit some money, and they get to be different people somehow or other. And so when you have these kinds of disagreements with somebody who says that's not the way I understand it, and then you have to go through the whole shebang. My feel is that if it's a legal problem, you really rely a great deal on whatever the lawyer says. If it's a human problem, you try to figure it out yourself. I have used ministers, rabbis, or priests, and even once a mullah who came in to help with the situation. So yeah, it's difficult, and you have to figure it out somehow that hopefully ends with people being at least semi-happy.
Fantastic. Jane, I was going to ask if you might talk about when disagreements have come up, how you've counseled folks to take care of those or to resolve them.
Well, mediation is always a possibility, or bringing in a professional fiduciary if it's 2 family members can't get along. Usually they come to some kind of an agreement, but if it's passing property along, where you run into more problems with people not is when, like, their mother's ill and they're fighting over where she should be placed, or whether the machine should be turned off, or the kinds of things that are hit a much more emotional thing. And then again, I think it was Ruth, brought up the principle of the thing argument, that I'm going to fight this for all the beneficiaries because it's the principle of the thing. This is wrong, blah, blah, blah. And, it ends up hurting everybody. So, mediation is a possibility, but lots of times lawyers get involved, and that can be extremely expensive and antagonistic.
Excellent. Thank you so much for those words of caution to the folks out there. We're kind of running out of time. And so I'd like to ask if you could sort of answer the last 2 questions in combination. For folks who are preparing their estate plan, their trust, choosing a trustee, do you have any parting advice for them, final words of wisdom, or something you'd like for them to hang on to as they leave this today? Ruth, I'll ask you first, please. Or Jane, go ahead. You started.
No, I was just going to pick a Ruth. Pick somebody honest, competent, fair, and who understands accounting and the kind of paperwork that's involved with it. If they don't understand that, but they're a real sweet person, they're the wrong person for your trusteeship.
She said it all. That's exactly right. That's just what has to happen. The other thing that has to happen is for the person who is the grantor to have absolute trust in the trustee. So then I think
Excellent.
things work out pretty well.
And so we do have time for the final question. I'd like to ask you, Ruth, to answer first on this. What advice do you have for the people who know now they will be trustees but are not yet?
Look at it carefully, understand both yourself, what your
Mhm.
capacities are, because it is absolutely necessary that you be a caring person, but also somebody who is absolutely accurate on keeping the records for everything that has to be done, and work as a team with whoever is the grantor, but also all the other people that are involved.
Wonderful. And as we're here at the end, we have a question that's come in, and I just have to read this. So it says, how do you find a Ruth or a fiduciary?
It should be, she is a fiduciary.
That's right.
Better than a fiduciary. Well,
If you'd like,
I
you can
think
write
most
to us and we'll give you her email address. How's
No,
that?
you won't. No, you won't. No, but I think, I think that most people know, they really do know who they trust to have them carry on the kinds of things they really want to have carried on after they pass on. You really
wonderful
know that.
advice.
You do.
Thank you both so very much.
Thank
And
you.
Thank you for having us.
Yeah.
I echo that. It has been a pure joy. And Mark, I want to thank you as well. One thing I want to send people away with is first, if you have any questions that have not been answered, there at the end, you can see our business cards are at the end of the PowerPoint. Just click on either one of them. It will take you directly to our email. Write to us. We'll see if we can't help you out. I need to emphasize one last time. It's as important as it is to pick the right doctor as it is to pick the right lawyer.
Good.
With that, I want to thank you all for the time you've taken. Jane, Ruth, I want to thank you once again on behalf of everyone at the Carter Center. Thank you so very much. Take good care. God bless.